going to open, Mr. Gelke?
Yes, sir. Thank you. Circuit Court, Hardin County, Tennessee is now in session pursuant to adjournment. The Honorable C. Creed McGinley presiding. God bless the United States, the state of Tennessee, the county of Hardin, and this honorable court. You may be seated.
When he does that, I always feel like we ought to sing Star Spangled Banner or God Bless America or something. He does a great job, puts the music on. Did somebody hint to y'all that it would be more convenient if you would file in the order in which you were seated? Somebody told you that?
Yes, sir.
Because I've done this a long time. If we don't tell you that, it's usually the second day of a trial before the jury figures out, hey, if we line up, we don't have to stumble across everybody. First of all, let's get one of the things out of the way. You were instructed not to view, listen to any news reports, not to make any independent investigations, avoid social media, so forth and so on. If you followed the court's instruction, please raise your hand. Let the record reflect we've got 15 people that raised their hand in the affirmative. Okay, we're getting ready to start the trial. Do you want to check witnesses? Are we ready for the jury to be sworn?
Well, Your Honor, we'd like to just make sure there's no, we had subpoenaed several people. We wanted to see if anyone was actually in the courtroom that had responded to a subpoena. If so, could they please step outside? We have somebody to meet with.
When she says that, she is essentially calling for the rule of sequestration of witnesses, as the state would also. If you are a witness in this case, first of all, you are to be excused from the courtroom. You're not to listen to the testimony of any witness that testifies. You are not to discuss with any witness testimony that's been given in the open courtroom. The state has designated as their representative, Ms. Bobo. She'll be allowed to stay in the courtroom, and they say if she is called, she'll be called towards the front of their witness. Correct? All right. In this case, State of Tennessee versus Zachary Wright Adams. State ready to proceed.
We are, Your Honor.
Defendant ready to proceed.
Yes, Your Honor.
All right. Let the record show reflect that both sides have indicated ready to proceed. What we will be doing, first of all, you got a notebook in your chair. In that notebook, there are the preliminary instructions that I will read to you in just a moment. They're very generic. If you sat on cases that I've done, any of you sat on cases I've done in the past. Okay. I've been doing this for 30 years, so you've been fortunate. But a lot of times I'll charge more. There are some very generic things in that initial charge that hopefully will guide you concerning credibility of witnesses, some other generic things. Later, after the conclusion of evidence, we will get your notebooks back. We will then put behind a divider another section of charge. That will include the elements of the offenses as well as any possible lesser included offenses and some other items that, based upon what the proof develops, the court will give you further instructions on. After that, the attorneys will make their closing statements, and you will get a final, just very brief final instruction that will be behind the next tab in there. The other thing you have in there, I told her to do fresh notebooks, all notebooks. Some people take voluminous notes. Some people just kind of get the highlights to remind themselves. You've got that in there. It's your personal preference. There's a pencil and a notebook. And probably the first thing I would do in those notebooks, the cover sheet, why don't you pull that up just a little and write your name on it. It's behind the plastic there. get extra pencils and extra notebooks. So if your pencil breaks or you run out of lead, I hope you don't, then if you need another writing instrument, we'll take care of it, okay? All right, we're ready to commence the trial. State ready to read the indictment. All right. If the state will read the indictment. The indictment is the formal written accusation that charges the defendant with a crime.
She went up and swore me.
Oh, that's what I asked. Okay. Madam Clerk, you'll swear the jury to try the cause. Let the record reflect we've got 3 built-in alternates. The names will be drawn at random. Hopefully everyone will remain safe. Okay.
Please be stand in the case of State of Tennessee versus Zachary Wright Adams and render a true and accurate verdict according to law and evidence so help you God. Will bitch you do that? Yes. Be seated, please.
Thank you. All right, the formal reading of the indictment, please.
State of Tennessee versus Zachary Wright Adams, Jason Wayne Autry, John Dillon Adams. Count 1. State of Tennessee, Decatur County, Circuit Court, May 2015 term. Grand jurors of the state of Tennessee, duly selected, impaneled, sworn, and charged to inquire for the body of the county of Decatur in the state aforesaid upon their oath present that Zachary Wright Adams, Jason Wayne Autry, and John Dillon Adams, heretofore to wit between April the 12th. May I approach the bench?
Yes.
Body of the county of Decatur in the state aforesaid upon their oath present that Zachary Wright Adams, heretofore between April the 12th, 2011 and September the 8th, 2014, before the finding of this indictment, in the county of and state aforesaid did unlawfully and with the intent to commit kidnapping, kill Holly Lynn Bobo in the perpetration of or attempt to perpetrate kidnapping, thereby committing the offense of first-degree murder in violation of Tennessee Code Annotated Section 39-13-202 against the peace and dignity of the state of Tennessee. Second count, the grand jurors of the state of Tennessee duly selected, impaneled, sworn, and charged to inquire for the body of the county of Decatur in the state aforesaid upon their oath present that Zachary Wright Adams, heretofore to wit between April the 12th, 2011 and September the 8th, 2014, before the finding of this indictment, in the county and state aforesaid did unlawfully and knowingly remove or confine Holly Lynn Bobo so as to interfere substantially with the liberty of said Holly Lynn Bobo, and the removal or confinement was accomplished with a deadly weapon or by display of an article used or fashioned to lead said Holly Lynn Bobo to reasonably believe the article to be a deadly weapon, thereby committing the offense of especially aggravated kidnapping in violation of Tennessee Code Annotated 39-13-305 against the peace and dignity of the state of Tennessee. Third count, the grand jurors of the state of Tennessee duly selected and panel sworn and charged to inquire for the body of the county of Decatur in the state aforesaid upon their oath present that Zachary Wright Adams, heretofore to wit between April the 12th, 2011 and September the 8th, 2014, before the finding of this indictment in the county and state, did unlawfully and knowingly remove or confine Holly Lynn Bobo so as to interfere substantially with the liberty of with the liberty of the said Holly Lynn Bobo, and that she did suffer serious bodily injury, thereby committing the offense of especially aggravated kidnapping in in violation of Tennessee Code Annotated Section 39-13-305 against the peace and dignity of the state of Tennessee. Fourth count. The grand jurors of the state of Tennessee duly selected, impaneled, sworn, and charged to inquire for the body of the county of Decatur in the state aforesaid upon their oath present that Zachary Wright Adams, heretofore to wit between April the 12th, 2011 and September the 8th, 2014, before the finding of this indictment in the county and state aforesaid, done unlawfully and with the intent to commit rape, kill Holly Lynn Bobo in the perpetration of or the attempt to perpetrate rape, thereby committing the offense of first-degree murder in violation of Tennessee Code Annotated Section 39-13-202 against the peace and dignity of the state of Tennessee. Fifth count. The grand jurors of the state of Tennessee duly selected, impaneled, sworn, and charged to inquire for the body of the county of Decatur in the state aforesaid upon their oath present that Zachary Wright Adams, heretofore to wit between April the 12th, 2011 and September the 8th, 2014, before the finding of this indictment in the county and state aforesaid, did unlawfully and intentionally, knowingly or recklessly sexually penetrate Holly Lynn Bobo by the use of force or coercion while armed with a weapon or an article used in a manner to lead Holly Lynn Bobo to reasonably believe it to be a weapon, thereby committing the offense of aggravated rape in violation of Tennessee Code Annotated 39-13-502 against the peace and dignity of the state of Tennessee. Sixth count. The grand jurors of the state of Tennessee duly selected, impaneled, sworn, and charged to inquire for the body of the county of Decatur in the state aforesaid upon their oath present that Zachary Wright Adams, heretofore to wit between April the 12th, 2011 and September the 8th, 2014, before the finding of this indictment in the county and state aforesaid, did unlawfully and intentionally, knowingly or recklessly sexually penetrate and cause bodily injury to Holly Lynn Bobo, thereby committing the offense of aggravated rape in violation of Tennessee Code Annotated Section 39-13-502 against the peace and dignity of the state of Tennessee. Seventh count. The grand jurors of the state of Tennessee duly selected, impaneled, sworn, and charged to inquire for the body of the county of Decatur in the said state, in the state aforesaid upon their oath present that Zachary Wright Adams, heretofore to wit between April the 12th, 2011 and September the 8th, 2014, before the finding of this indictment in the county and state aforesaid, did unlawfully and intentionally, knowingly or recklessly sexually penetrate Holly Lynn Bobo by the use of force or coercion while being aided and abetted by one or more other persons, thereby committing the offense of aggravated rape in violation of Tennessee Code Annotated Section 39-13-502 against the peace and dignity of the state of Tennessee. Eighth count. The grand jurors of the state of Tennessee duly selected, impaneled, sworn, and charged to inquire for the body of the county of Decatur in the state aforesaid upon their oath present that Zachary Wright Adams, heretofore to wit between April the 12th, 2011 and September the 8th, 2014, before the finding of this indictment in the county and state aforesaid, did unlawfully, intentionally, and with premeditation kill Holly Lynn Bobo, thereby committing the offense of murder first degree in violation of Tennessee Code Annotated Section 39-13-202 against the peace and dignity of the state of Tennessee. This 8-count indictment was returned a true bill by the foreperson of the grand jury on May the 19th, 2015.
She told me my mic's not on. That's never been a problem, okay? How does the defendant plead?
Not guilty of all charges.
All right. As I was doing some of my paperwork, it came to mind. Today is September 11th. 16 years ago, our country changed forever. Is there anyone here that does not remember what you were doing on 9/11 when the towers went down? That's how important that event is. As I said, it changed our lives forever. So we need to give thought to the people that lost their life on that day and continue to have our thoughts and prayers to the people that are still affected. As you noticed, as you read the indictment, reference was made to Decatur County. I'm sure it does not escape you that the court had to change where we selected jurors from because, in the court's opinion, it would have been absolutely impossible to get fair jurors. There might be some, but it would be extremely difficult and I thought impossible to draw the jury from Decatur County. So it has legally been changed here. The physical venue, as I will charge you, is Decatur, but the binary is the word for the jurors, has been selected from Hardin County. So there has been a change of venue for purposes of selecting jury. Each of you understand that? Yes. Okay, thank you. If you wish to follow along, I'll be reading a portion of the charge, then we'll get into opening statements. The first page of your book there, I'm going to go back through that. These are the admonitions. In order to assure the parties a fair trial, jurors are asked to conform their conduct to the following rules. Do not form or express an opinion on the case until instructed by the court to do so. Do not discuss the case with anyone, not even the appellate jurors, until the case is submitted to you for your final consideration. Do not allow the case to be discussed in your presence. Ignore, as I've told you from the outset, any news reports. Avoid conversations with parties, witnesses, or attorneys, and report promptly to the court any violation of these rules. I've added to that to tell you not to be on the internet, not to make any independent investigation. I think your access to internet has been terminated, so that shouldn't provide any problem. And I apologize for doing it, but that's the only way that we can safely take this case to its conclusion without having to worry about outside influence. So I hope you appreciate that. And some of you might get fidgety not having these devices, but you'll have to endure that hardship. I don't use mine as much as a lot of people, but if I discover that I don't have my cell phone, I usually will turn around and go back home and get it. So it's become an important way of life for us. So I apologize for doing that. Now, if you'll turn the page, this is only 8 pages. If you wish to follow, you may do so. Members of the jury, the defendant, Zachary Rye Adams, is charged in Hardin County case number 17-CR10 with the following offenses. Counts 1 and 4 charge first-degree felony murder under alternative theories. Counts 2 and 3 charge especially aggravated kidnapping under alternative theories. Counts 5, 6, and 7 charge alternative theories, and count 8 charges first-degree premeditated murder. The defendant pleads not guilty to each and every offense embraced in the indictment. You have been selected and sworn to serve as the jury in this case. Prior to the presentation of the evidence, I'm going to give you some instructions to help guide you in applying the law and evaluating the evidence that is presented. The order in which these instructions are given is no indication of their relative importance, and you should not single out one or more of them to the exclusion of another or others, but you should consider each one in light of and in harmony with the entire charge or set of instructions. The law which applies to this case is stated in this charge, and it is your duty to carefully consider all of the instructions in arriving at your decision. Whenever the singular of a word is used in these instructions, it may be taken equally to mean the plural. The indictment in this case is the formal written accusation charging the defendant with a crime. It is not evidence against the defendant and does not create any inference of guilt. At times during the trial, I will rule on the admissibility of evidence. You must accept with these rulings. Neither by such rulings, these instructions, or any other remarks which I make do I mean to indicate any opinion as to the facts or as to what your verdict should be. Statements, arguments, and remarks of counsel are intended to help you in understanding the evidence and applying the law, but they are not evidence. If any statements are made that you believe are not supported by the evidence, you should disregard them. As to any question to which an objection may be sustained, you must not speculate as to what the answer might be or as to the reason for the objection, and you must assume that the answer would be of no value to you. You must not consider for any purpose any offer of evidence that is rejected or any evidence that is stricken out by the court. Such matters shall be treated as though you never knew it. You must never speculate to be true any insinuations suggested by a question asked a witness. A question is not evidence and may be considered only as it supplies meaning to the answer. You, as yours, must decide this case based solely on the evidence presented here within the four walls of this courtroom. This means during the trial you must not conduct any independent research from any source about this case, the matters and the individuals involved in this case. As you know, you will be sequestered for the duration of this trial. As a result, you will not have access to reference materials of the internet. Again, do not try to find out information from any source outside the confines of this courtroom. To deliberate at the close of all the proof, you may not discuss the case with anyone, even your fellow jurors. When you retire to deliberate, you may begin discussing the case with your fellow jurors, but you cannot discuss the case with anyone else until you have returned a verdict and the case is over. I hope that for all of you this case is interesting and noteworthy. You also must not talk to anyone about this case or communicate electronically with anyone about the case. This includes your family and friends. You, as yours, must base your decision solely on the evidence you hear in the courtroom. You are the exclusive judges of the facts in this case. Also, you are the exclusive judges of the law under the direction of the court. You should apply the law to the facts in deciding this case. You should consider all of the evidence in the light of your own observation. You should consider all the evidence in the light of your own observations and experience in life. A person accused of a crime is presumed. This means that you must start with the presumption that the defendant is innocent. This presumption continues throughout the trial, and it entitles the defendant to a verdict of not guilty unless you are satisfied beyond a reasonable doubt that he is guilty. The defendant is not required to prove his innocence or to do anything. Every crime is made up of elements. The state must prove each element of the crime beyond a reasonable doubt. If you find that the state has not proven every element beyond a reasonable doubt, then you must find the defendant not guilty. Reasonable doubt is that doubt engendered by the investigation of all the proof in the case and an inability after such investigation to let the mind rest easily as to certainty of guilt. Absolute certainty of guilt is not demanded by the law to convict of any criminal charge, but moral certainty is required, and this certainty is required as to every element of proof necessary to constitute the offense. If you find the state has not proven every element of the offense beyond a reasonable doubt, then you should find the defendant not guilty. The state must prove beyond a reasonable doubt all the elements of the crimes charged. In addition, the burden is upon the state proved by a preponderance of the evidence that this offense was commenced or consummated in Decatur County, Tennessee. Proof by a preponderance of the evidence means the weight of the evidence must be in support of the state's contention. Venue of the offense lies in the county where the offense was commenced or consummated. If you find that the state has failed to prove by a preponderance of the evidence that this offense was commenced or consummated in Decatur County, Tennessee, then you must return a verdict of not guilty. During this trial, you may take notes concerning the evidence presented in court. The notes are simply to assist you in remembering what transpired. The notes are not evidence or a transcript of testimony. They are not a substitute of your recollection of the evidence you saw or heard in court. If you do choose to take notes, do not let your note-taking interfere with your attention to the evidence presented in the case. You must watch and listen carefully to the evidence. You may use your notes during deliberations to the extent that you think that they are helpful. But the fact that a particular juror has taken notes does not mean that juror's views should be given any greater weight than those of any other juror. It is your job to decide what the facts of this case are. You must decide which witnesses you believe and how important it is. You do not have to accept or reject everything a witness said. You're free to believe all, none, or part of any person's testimony. In deciding which testimony you believe, you should rely upon your own common sense and everyday experience. There's no fixed set of rules for judging whether you believe the witness, but it may help you to think about these questions. Was the witness able to see or hear clearly? How long was the witness watching or listening? Was something going on that might have distracted the witness? Did the witness seem to have a good memory? How did the witness look and act while testifying? Did the witness seem to be making an honest effort to tell the truth, or did the witness seem to evade the questions? Has there been any evidence presented regarding the witness's intelligence, respectability, or reputation for truthfulness? Does the witness have any bias, prejudice, or personal interest in how the case is decided? Have there been any promises, suggestions, or other influences that affected how the witness testified? In general, does the witness have any special reason to tell the truth or any special reason to lie? All in all, how reasonable does the witness's testimony seem when you think about all of the other evidence in the case? Sometimes the testimony of different witnesses will not agree, and you must decide which testimony you accept. You should think about whether the disagreement involves something important or is simply mistaken. People see and hear things differently, and witnesses may testify honestly but simply be wrong about what they thought they saw or remembered. It's also a good idea to think about which testimony agrees best with the other evidence in the case. However, you may conclude that a witness about something that is important to how you decide the case. If so, you may choose not to accept anything the witness said. On the other hand, if you think the witness lied about some things but told the truth about others, you may simply accept the part you think is true and ignore the rest. A witness may be impeached by proving that they have material statements out of court which are at variance with their evidence on the witness stand. However, proof of such prior inconsistent statements may be considered by you only for the purpose of testing the witness's credibility and not as substantive evidence of the truth of the matter asserted in such statements. Further, a witness may be impeached by a careful cross-examination involving the witness in contradictory, unreasonable, and improper statements. However, immaterial discrepancies or differences in the statements of witnesses do not affect their credibility unless it should plainly appear that some witness has willfully testified falsely. When a witness is thus impeached, the jury has the right to disregard their evidence and treat it as untrue, except where it is corroborated by other credible testimony, facts, and circumstances proved on the trial. The rules of evidence provide that if scientific, technical, or other specialized knowledge might assist the jury in the evidence or in determining a fact and issue, a witness qualified as an expert by reason of special knowledge, skill, or experience may state opinions concerning such matters and give reasons for his testimony. Merely because an expert witness has expressed an opinion does not mean, however, accept this opinion. The same as with any other witness. It is up to you to decide whether you believe this testimony and choose to rely upon it. Part of that decision will depend upon your judgment about whether the witness's background or training and experience is sufficient for the witness to give the expert opinion that you heard. You must also decide whether the witness's opinions were based on sound reasons, judgment, and information. You are to give the testimony of an expert witness such weight and value as you think it deserves, along with all of the other evidence in the case. There are two kinds of evidence, direct and circumstantial. Is direct proof of a fact, such as testimony of a witness about what the witness personally observed. Circumstantial evidence is indirect evidence that gives you clues about what happened. Circumstantial evidence is proof of a fact or a group of facts that causes you to conclude that another fact exists. It is for you to decide whether a fact has been proved by circumstantial evidence. Do not assume that direct evidence is always better than circumstantial evidence. Either type of evidence can prove a fact if it is convincing enough. A defendant may be convicted on direct evidence, circumstantial evidence, or both. When the evidence is entirely circumstantial, then before you would be justified in finding the defendant guilty, you must find that all the essential facts are consistent with the theory of guilt, and the facts must exclude every other reasonable theory except that of guilt. You are to consider both direct and circumstantial evidence. The law permits you to give equal weight to both, but it is for you to decide how much weight to give to any evidence. In making your decision, you must consider all of the evidence in light of reason, experience, and context. If the defendant testifies on his own behalf, his credibility will be determined by the same rules by which the credibility of other witnesses is determined, in such weight as you may think is entitled. If the defendant does not take the stand to testify as a witness, you shall place no significance on this fact. The defendant is presumed innocent, and the burden is on the state to prove guilt beyond a reasonable doubt. He is not required to take the stand in his own behalf, and his election not to do so cannot be considered for any purpose against him, nor can any inference be drawn from such fact. This concludes my opening instructions. I will give you further instructions after the presentation of evidence concerning the charged offenses and any lesser included offenses as well as other principles of law. Let me say this, I've asked that our officers maintain order. There will be no going and coming except during recess. The exception is if you've got an emergency and you need to leave, there might be something urgent that somebody needs to leave, you can go, but you won't come back in until the next, till we begin again. So everybody needs to be aware we're doing this so that there's not a lot of distractions and everyone can listen and pay attention as we go through the evidence in this case. This time we're ready for opening statements. I've been through this during jury selection, but the state has the burden of proof, so they will go first at each stage of the trial. So they will do their opening, followed by the defendant's opening. I remind you again that what the attorneys say is not evidence, but opening statement gives them the opportunity to essentially lay out their respective theories of the case. So